So it's true that the executive power vested in the president is fundamentally a power to execute the law. But it's been the case over the last 60, 70, 80 years that Congress delegates to the president extraordinarily broad powers. And it's really these broad authorities that allow presidents way too much discretion that, in my view, is the problem.
Since the federal immigration crackdown started in Minnesota, we've seen a number of incidents that appear to have violated several amendments to the U.S. Constitution. The First, Fourth, 10th, and 14th Amendments come to mind. There were concerns over the Second Amendment, too, since Alex Preddy was illegally carrying a gun at the time of his shooting death by federal agents in Minneapolis. Now, if you can't recall what these amendments are from your civics class, we'll run down some of them for you. The First Amendment, as you know, guarantees the right to free speech. But during this surge of ICE and Border Patrol agents, some protesters and observers report government intimidation and retaliation for their actions. That violates the First Amendment. We've seen a couple of journalists indicted as well. The Fourth Amendment protects individuals from unreasonable searches and seizures. Video of agents barging into homes, guns drawn, entering without proper judicial warrants is a textbook example of a violation of the Fourth Amendment. The lawsuit against the federal government over the ICE surge brought by the state and the cities of Minneapolis and St. Paul relied on the 10th Amendment. That amendment is often referred to as the States' Rights Amendment. It affirms the federal government only has powers specifically delegated to it by the Constitution, and all other powers belong to the states or the people themselves. Finally, there's the 14th Amendment that's been in question. The 14th Amendment grants citizenship to all persons born or naturalized in the United States, birthright citizenship. It also states, "Nor shall any state deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the law." So we ran down some of those amendments. What are the ramifications of the Trump administration's clash with the First, Fourth, 10th, and 14th Amendments? We're joined by University of Minnesota law professor Ilan Wurman. Professor Wurman specializes in the 14th Amendment, administrative law, separation of powers, and constitutionalism. Professor, it's a pleasure. Thanks for taking the time.
Thanks for having me on your show.
I mentioned the First, Second, Fourth, 10th, and 14th Amendments have all been mentioned in reporting of the ICE surge in Minnesota. Given what we've seen, has the Trump administration overextended its powers as they relate to those amendments? What's your view?
So it's always the case that individual officers might exceed legal authority. So, for example, officers are not allowed to engage in excessive force. And if they engage in excessive force, that may be, for example, a Fourth Amendment violation. It doesn't follow that the administration as a whole has a policy of violating the Fourth Amendment. So same thing with the First Amendment. It's obviously true that individuals have a right to protest, but they do not have a right to interfere with the operations of federal law enforcement. And so in any particular case, the First Amendment might be violated by the actions of a particular officer, but it's very different from saying that there is a widespread policy of violating these amendments.
I'm curious, the 10th Amendment is the guarantee, if I'm right, of state sovereignty in areas not given to the federal government. And as you know, the state of Minnesota sued the federal government using the 10th Amendment, arguing that the ICE surge violates the 10th. Do you think there's constitutional standing for that case?
No, and the Biden administration appointed the judge who actually heard that case and dismissed it. It's a true. The 10th Amendment is often said to be a truism. The states have reserved power where the federal government does not have power. So the federal government has only enumerated powers in Article 1, Section 8. But within the federal government sphere, I don't think anybody really denies that federal law is supreme over contrary state law. That's Article 6 of the Constitution. There's a supremacy clause. Article 2 of the Constitution also says that the president has a duty to faithfully execute the laws, and that includes in all the states of the union. So on the assumption that immigration is a federal power, then I don't think anybody disputes that the national government has the right to go in and enforce those laws. Now, it's an interesting question. Article 1, Section 8 doesn't mention immigration anywhere. So there's a little bit of a debate among scholars where precisely this power comes from. Maybe it's the foreign commerce power. Maybe it's Congress's power to define offenses against the law of nations. But look, the Supreme Court in the 1880s said plenary power, inherent attribute of sovereignty. And I don't think anybody really debates seriously today whether the government has this power. And so they have a right to do it in a constitutional manner.
What does that mean exactly, in a constitutional manner?
So again, if as long as the statutes permit the use of ICE officers from out of state to go and enforce the laws in Minnesota, then that would be perfectly constitutional. If the statutes prohibited it, then it would not be constitutional because the president can only execute the laws with whatever officers and finances and wherewithal that Congress gives the president. Here, I don't think anybody argues that the statutes preclude that. But even if ICE is allowed, it has to act consistently with the First Amendment and the Fourth Amendment and the 14th Amendment. But those are really as applied questions. Do individual officers exceed their authority in any particular cases?
I mentioned in the introduction you specialize in the 14th Amendment, which I believe was approved post-Civil War, right?
Correct.
And if I'm remembering my civics class, I think the drafters were trying to eradicate state-sponsored violence against Black people. What are the lessons in that amendment that reflect the Minneapolis experience?
So first, I just have to issue this disclaimer. My 14th Amendment expertise ends around the 1880s. I'm very much, I like legal history, and I wrote about the original meaning of the 14th Amendment. But having said that, I do know how the amendment has been subsequently interpreted. And it is certainly the case, you are correct, Cathy, that the idea of the amendment was to grant civil rights to the newly freed people, right? The newly freed men and women in the South on equal terms with white citizens. Now, where exactly this comes from, there's the Equal Protection Clause, which everybody understands today as the source of equality. But the point is, under the 14th Amendment, at least when the states are involved, and here it's tricky because it's the federal government. So there's like this extra step, right? But at least when the states are involved, it is understood that racial classifications are not always invalid, but almost always invalid. Racial classifications are given what's called strict scrutiny. Like you have to really show that race is relevant to the thing in question, to the right in question, to the government program in question. Now, what about the federal government? Well, the 14th Amendment doesn't apply to the federal government, but the Supreme Court in the 1950s has held that it would be kind of crazy to think that the states are not allowed to discriminate on the basis of race, but the federal government is. And so they held that the Fifth Amendment, the Due Process Clause, reverse incorporates, it's this crazy legal term, but reverse incorporates this equal protection principle against the federal government. So we're talking about the 14th Amendment, but actually when the federal government is involved, what we're really talking about is the Fifth Amendment's Due Process Clause has been held to have this equal protection component applicable to the federal government.
I was talking to another scholar who said one of the lessons that you draw from the 14th Amendment is if you can't be physically secure in your community, you can't really enjoy the liberties and freedoms and all the promises that the Constitution provides. Does that make sense to you in terms of the context of what we're seeing in Minneapolis?
I mean, absolutely. As a historical matter, this goes to what was the original meaning of the equal protection of the laws. We think of the 14th Amendment today as simply targeting state action. The state must do something affirmatively in order to deprive you of rights. But actually, the protection of law was a government obligation. It was an obligation to protect individuals in their private rights to life, liberty, and property against private violence and private interference. So like the Ku Klux Klan, if this were violating the rights of the freed people in the South, and if the state governments failed to protect the freed people, that would be a denial of protection of the laws. So here, of course, it's a little bit different because the federal government is taking affirmative actions. So it isn't really a question of this failure to protect, but it was this requirement generally for a protection of one's rights against not only government interference, but private interference and private violence.
I'm curious here, the situation in Minnesota continues what some legal scholars on the left say has been a brazen assault on the U.S. Constitution since the president took office here for a second time last year. And as you know, there's some alarm that the president is pushing the country toward authoritarianism. And I wonder whether you, as a scholar with a more conservative bent perhaps, or view, feel as though the Trump administration's actions could result in the long-term erosion of the framers' vision of balanced governmental powers.
That's a great question. And the truth is, I often don't know what people mean by electoral autocracy or authoritarianism. So we have to define those terms. So what's going on in Minnesota, this desire to enforce federal laws? Well, Andrew Jackson in Congress wanted to enforce federal law in the South when the South purported to nullify laws that they didn't like or think were unconstitutional. So in a way, the argument that the federal government isn't allowed to enforce the laws in Minnesota comes out of the old South, right? So I don't think it's authoritarian to demand the execution of federal law. Now, it is true that historically there was a fear that the federal government would send a swarm of federal officers to oppress the people. Do you remember the Declaration of Independence? It accuses King George III of sending a swarm of federal officers to harass the people and eat their substance. People don't talk like that anymore today, but like what an allegation. And so there is like a concern of sending federal officers from out of state to swarm the state does raise these concerns. But as even the Biden appointed judge in this Minnesota case has recognized, there is an argument that these sanctuary city policies are what is inviting the execution of federal law. So historically, those who were distrustful of federal government power actually wanted state officers to assist in enforcing federal law because they didn't trust a swarm of federal officers, possibly from out of state, coming in and potentially harassing the people. State officers, local sheriffs, they were elected by the people of the state. They were usually closer to the community and could sort of interpose between federal law and the people, but it requires some degree of cooperation, right? So I actually do agree that sending federal officers from out of state to make a point about the enforcement of federal law risks potential, I don't want to call it authoritarianism, but it risks aggrandizing the federal government's power in a way that we feel uncomfortable with. But they do have a right to see the laws executed, and the states could do things that would mitigate and minimize the federal role. And I think that's actually what's transpiring in Minnesota, right? The talk between Governor Walz and President Trump, bringing in Tom Homan. It sounds to me like the state is finally agreeing, like, okay, maybe if we did just give you like the worst of the worst who are in our jails, who are not only here unlawfully, but also committed other crimes, if we give those to you to enforce, will you, remove federal officers? And that seems to have been the agreement. It sounds like the federal government has agreed to remove federal officers, and that federal state cooperation is what we actually want. And so I hope that that's a sign of some more cooperation to come.
I'm wondering, the president, as you know, frequently asserts that he is acting under the authority granted to him by Article 2 of the Constitution. But in fact, as you know, the Constitution's intended to limit the powers of the presidency. And I'm wondering if you get a little worried, as being a constitutional scholar, that the president might have nearly limitless authority in his view.
Yeah. So I don't know that this is actually unique to President Trump, right? So it's true that the executive power vested in the president is fundamentally a power to execute the law. But it's also, so the president can't really do anything without Congress acting first. The president can't go beyond the statutes. The president can't be a lawmaker, right? That's the famous Youngstown steel seizure case. President Truman was not allowed to seize the steel mills when there was a work stoppage merely because of the Korean War. Now, there's no law that allowed that. You have to follow Congress's law. But it's been the case over the last 60, 70, 80 years that Congress delegates to the president extraordinarily broad powers. And it's really these broad authorities that allow presidents way too much discretion that, in my view, is the problem. Is it true that presidents try to stretch the scope of their statutory authority? Yes, of course. But the Obama administration did that with the Clean Power Plan. The Biden administration did that with student debt relief. Every president loves to stretch the statutory authorities that delegate power to the president. Everyone does it. So I'm an equal opportunity skeptic of executive power, if that makes sense.
Professor, I have appreciated your time. Thank you so much. Very interesting.
It's my pleasure.